Welcome everyone, it's great to have you with us this afternoon. We will be joining Metka Potočnik on the subject of image copyright. Please use the Q&A box if you have any questions and we'll go through them during the talk and perhaps at the end as well. Just a reminder that this is a public platform and the session is being recorded, so please do not share any confidential information. Welcome Metka, over to you.
Thank you, Claire. I am, for anyone who knows me, I am quite happy to take questions as we go along. I have also asked Claire to be my lingo check, if you will. So hopefully I'm not going to be using too many lawyer type expressions, but if I do, Claire will hopefully be there to correct me. So Claire, can you just check with me that you can see my slides okay?
Yep, looks good.
Perfect. And for everyone, I would really welcome you to this talk, and I would encourage you to ask your questions as we go along. So we've discussed it with Claire as well. So if you sort of have a question as I'm talking around certain concepts, please put it in the Q&A and Claire will ask it to me, and hopefully I will be able to answer, or if not, we'll make a note and we'll answer it in a different forum or after the session has ended. Now, today we are focusing on a very narrow overview around images, but of course, copyright covers much more than that. And hopefully that's why we will just start a conversation. And we are thinking about designing a set of workshops with our artists, regional or from the university, to perhaps give you some of the tools and insights into the intellectual property laws, rights, and operations. So copyright covers just some of the creative works you would have created perhaps in your practice. If you're in fashion, you might be looking more at design rights. If you are also having a business side of things, you might be looking into trademarks, which are commercial signs when we're selling items on the market facing consumers. Or perhaps you've come up with a new technical solution to a technical problem, so you might be interested in knowing more about patents. So it all depends on your creative practices, and your needs might perhaps not be addressed really today. But even if you are here where focusing on a very specific area in your artistic practices, you might have more broadly questions around images that you found online or you found elsewhere, and what you can and cannot use. Now, the Q&A is open for you if you want to use it there, or even if you want to connect on Twitter. I'm on Twitter, and I do use it for university things. You can also use the hashtag, so WLV Art Law. We'll address those after the session as well. And the outline for today is really briefly around what is copyright and what does it protect, what kind of rights are given by copyright, and are there any defenses of thinking about what can you do with other people's work, which is protected under copyright? And then specifically, because there were a few questions already from different members of the community when we were preparing the talk, I did want to touch around images that we find online in different platforms. I'll use the Twitter and Instagram apps as just like a case study to give you a little bit of an impression, but I do think it's important to just perhaps understand how images found online, what do they allow you to do with them, and can you just freely use them once you found them. So what is copyright? I think rather than going into the specifics of legal provisions, so I haven't refer to a single act in this talk, nor will I, but if you do have questions, please pop them in the chat, or we can come to that in a different setting, in a different workshop. But for now, there's certain key points I wanted everyone in the talk to take away from. And the first one is that copyright is a territorial right, which means that you will have copyright as a legal right in each and every country separately. So there is no such thing as a global copyright. There is no such thing as a world copyright. There were some exceptions when it comes to trademarks, but even that, now that we have left the EU, when looking and focusing on the UK context, we will have all rights territorial. So you will have a UK copyright, you will have a US copyright, Australia copyright, and so forth and so forth, which is very important for you to remember if you are ever venturing outside of the UK with your practices. So that's the first point, a general point. So all intellectual property rights are territorial in nature. So they're linked to specific states. The second one is that copyright, as all other intellectual property right, will give its proprietor, its owner, the rights holder, certain rights to control. So they are sometimes referred to as monopolies, they're referred to as exclusive rights, but it does mean that copyright will give you a list of rights that are reserved for your control. So unless you give permission to do something with the said creative work, which is protected by copyright, unless you give that permission, third parties, the world, does not have right and access to your creative work. So copyright gives, just like other intellectual property rights, it gives a set of monopolies, and we'll look at those rights in a few moments, okay? In the UK, as with most countries which have signed on to an international set of rules under the Berne Convention, so in the UK, we do not have to register copyright in order to be protected. So what does that mean? That means that as soon as you have created the work and have fixed it in the medium, expressed the idea of the work in the outside world, you will have copyright. You will have this legal monopoly attached to your creative work. So you do not have to go to the intellectual property office and say, please register my copyright in the said photograph or in the said painting, okay? You making the painting will give you, through legal mechanisms, will give you the copyright, will give you the set list of exclusive rights. So you do not have to register copyright, the work, to get access to copyright protection. You might have heard that in the US, there is such a thing as registration of copyright, but even then, it is not to have certain types of works protected. It is for the types of damages granted in it, should the case ever go to court. So it's a specific set of requirements in the US. In the UK, as with other countries in the European Union and elsewhere, there is no registration requirement for copyright. That is different to patents and trademarks. Okay, even with design rights, we have different systems in place. Okay, so certain designs are protected even when not registered. Different designs are protected only if registered, but we can have a look at that in a separate session. Okay, copyright is also a property right. And that means if you're running a business or if you're organizing your activities as an independent business owner, that copyright, just like other intellectual property rights, could be valuable assets. And certain businesses also use these valuable assets, even in cases like financial assets, to put them on the books or perhaps to use them as security against a loan. So copyright is valuable for its owner. Okay.
Now, we have
yes.
one question here. I don't know if you want to answer.
Absolutely, Claire. That's why I said let's do it like that. Yes.
Are you able to use the TM symbol next to your logo, even if you're not a registered trademark?
It doesn't. You can use whatever you want. It will give you no rights, nor will it omit any rights. So the TM logo is not something that is is not a legal consequence of a registration on the by the Intellectual Property Office. So the way it works in the UK, if you have a registered trademark, it is by way of registration you get all the extra rights. A registered trademark will give you a certain set of protections in the UK, but even if you have not registered a symbol, you might still get protection under passing off. So it's a separate type of legal protection. So the use of TM in a little circle does nothing really.
Okay, and another question's just come in, and John's asked, what about the C in a circle mark?
The same. It's just for fun. I mean, it's more known in the US, and like I've mentioned, there's some specifics around US registration of copyright because it's attached to different types of damages. So you can ask for more damages in the US if you go to courts, but again, you don't have to put a C to have copyright protection. So if you look at the conditions that you need to satisfy in the Act, there's no such thing as, you know, always use the C circle, otherwise you will not be protected.
That's interesting. We've got another question here. What about rights for music and instrumentals, lyrics? How does it work for exclusive?
I would love to talk 7 weeks around music and everything. And I would encourage, I'll say this much, okay? With music, which I'll come to, let me just say this and then I'll jump to answering this music question. So just remember that copyright is not just what you get, a right you might have, it might be a limitation to your own creative practice if there are other people who have creative works and have copyright in them. But with that, with the music question, let me now turn to perhaps what does copyright protect? And with a musical piece, you have different types of copyright attached to different creations. So with a musical composition, you will have a copyright attached to that. You will have the same option for literary work. So if you have lyrics to a song, that will have a separate copyright attached to it. And you will also see that sound recordings will have a different type of copyright attached to that as well. So that is why we talk about different rights in the music industry, which become quite complex. You have the publishers and the rights holders that they have their own set of rights, and sound recordings, for example, is where we're talking about master recordings. If you maybe sort of seen how there were disputes in the news reported where the rights to a song, to a musical work or a literary work are owned by the artist, but the sound recordings, the masters were recorded by the, let's say, a record label, and there is a split. So the record label then can control what will happen with those recordings. So musical works will have those set of rights, so rights over literary works, musical works, and sound recording. And not only that, you will also have a set of neighboring rights or performer rights attached to musical works as well. So with musical work, with music in the music industry, the plethora, the spread of intellectual property rights is quite complex. And despite the complexity of that, none of it really applies to streaming, where streaming is now being looked at by the Parliament through a separate legislative inquiry at looking at how do we fix streaming, how do we make sure that artists start making money through streaming. So Claire, with that, unless there's a follow-up question, I think I would leave the music side right now.
There is one little question. Doesn't PRS and MCPS help with music?
Well, they do for collective rights, absolutely, but it's still, it doesn't work really well for streaming. So with streaming, it is mostly the record labels that are being paid for the streams, and the better performing artists, so the more well-known artists, get paid better than independent artists, even if they're listened to by their fans. So it's not really working that well in streaming.
Okay.
I know I'm not giving an answer, but it's really not a set area of the law. So quite happy to take the blame, but it's an area that's currently really being discussed in the music industry and through the parliamentary hearings, which I have been watching online. Yeah, but I'm very happy to sort of look into setting up different workshops. And I'm also sitting on the F-list, which is the community interest company for women in music and promoting professional opportunities for women and gender minority artists in the music industry. So we are looking at really developing different kind of workshops and really looking at the rules being clarified and more easily accessible in the music industry. But it's a complex set of rights that are covered. But yes, PRS is one of the collecting societies in the UK, at least.
Okay, thanks, Metka. That's all for questions for the minute.
For the minute, all right, perfect. So there are different types of works copyright will protect, and you would have seen I've already spoken to literary musical works. So literary will not only cover poems and lyrics to songs. It's usually what we're looking at: novels, any kind of writings, even a recipe will fall under that particular definition. We then have dramatic, musical, artistic works, and artistic works through the topic of the image is what we're focusing on today. So these four categories, literary, dramatic, musical, and artistic works, are the ones where we see the most protection. They do have certain extra conditions that have to be met. So literary, dramatic, music, and artistic works are only protected by the Act, by the Copyright Act, if they meet a certain threshold. That certain threshold is that the works have to meet the necessary threshold of originality. And we know that from the law and the cases that that threshold is the work has to be author's own intellectual creation. So that is the standard, that is the legal test. And then that has been then assessed by judges in specific cases, right? So author's own intellectual creation, that does not mean what do the critics think of it? That does not mean how was it marked by tutors in a course, or even how it was reviewed by the papers. It really has to do with the type of creativity that we as human beings put into creative works, into literary works, musical works, artistic works, and the like. With films, sound recordings, broadcasts, and typographic arrangements of published editions. So the last one is what a page looks like in a printed book. So with these last ones, you don't have that second requirement of originality. And that means they are protected, but usually for a shorter period of time. And they're also protected only against identical copying. So if you were to take a sound recording, that identical sound recording, and try to play it somewhere else without permission, you would be infringing copyright. Now, with literary, dramatic, and music artistic works, the type of protection is broader. Why? Because the Copyright Act will protect against identical copying, but also against not only identical copying, but also against altered copying, so similar copying, right? So not when you actually take the painting, but also when you have indirect copying taking place by the artist. And this is where we come into difficulties when we have specific cases in front of us. With literary, dramatic, music, and artistic works, we also have additional requirements. So for literary, music, and dramatic works, we also have the requirement of fixation. So the works have to be recorded in a medium. So music, for example, has to be recorded, whether it's by notation or on actual recording. Literary works, they have to be written down, even if it is without permission of the author. Dramatic as well. You will see there's no specific requirement for artistic works. That has been discussed in case law as well, but I'm not going to go into specifics there right now. So there's no statutory, in the Act itself, there is no requirement for artistic works to be recorded. There's also a requirement of qualification, so there has to be a link with the UK. Remember, we said that all intellectual property rights are territorial, which means that either the author has to be British, or they reside here, say they are domiciled in the UK, or there is a connection with the UK by way of publication or showing of the work. Now, with artistic works, I just wanted to give you the statutory, the way lawyers sort of describe artistic works and what are the types of works that will get protection in the UK. And you will see that if you were to think about the image, which is at the forefront or in focus of today's session, you will see that that will cover graphic works, photographs, and you then have further definitions that any painting, drawing, diagram, and so forth and so forth. Just because we had a specific question in preparation around fashion and design. So for example, drawings of a particular design, that particular drawing would have copyright protection in it. But with design and fashion items, you would want to have that additional protection over appearance of products. So, if the design was for a jacket, you would want protection from other people making the same copies of your jacket, not just making copies of the particular diagram or picture. So you would want to have access to design rights, which are separate intellectual property rights as well. And we see also we have a definition of photograph and so forth and so forth. Okay. Before I jump into the rights, do we have another question, Claire?
Yeah, well, we had one from Manuel. He said, how does it apply to photographic composites? But I think you've just kind of touched on that a little bit.
Yeah, so photographs and composites would fall within artistic works.
Yeah.
So that would be covered. The only thing I think, which we will come to when it comes to infringement, so can you take from other people? It depends on what you've taken and how far. So in generally, you can be inspired by other people's work, but you can't copy substantial parts of other people's work without permission. And that's where it comes to the question of certain circumstances, and we have to look at what happened in the case in front of us.
Okay, one question from John here. So this is very useful, Metka, thank you. Can you mention Creative Commons?
I'm going to come to that. So John, if I can put a pin on it, I mean, Creative Commons is a beautiful doctrine, and I force my students to read that. They're very unhappy about it. So Professor Lessig was the one who came up with Creative Commons and described this tension with copyright. So initially it was about promoting and inspiring, facilitating artists to be more creative by rewarding them with these monopolies, with legal rights, with the monopolies. But now, in effect, because of the expansion we see in copyright, so currently for literary, music, dramatic works, and artistic, the duration of copyright is life plus 70. So that means as long as the author of the work is alive, plus 70 years after their death. So that is a very long period for protection that we have. And it means throughout the duration of copyright, if anyone wants to use that work in a new artistic venture, unless it is unrecognizable when used in that new forum, you would have to have either one of the defenses available, or you would have to have permission. And that, some would argue, is stifling creativity in other works. So Creative Commons is a response to that. And you actually now have different licenses, different types of permissions you can put on your work. And you're basically putting it on a platform and say, if anyone out there in the world wants to use my own work, these are the conditions under which they can do that. But I'll come to that I have a little picture and a little slide. And please remind me if you wanted to discuss that as I come to it, if that's all right, Claire?
That's great, thank you.
Perfect. So let me just jump towards a brief overview, of course, around rights given by copyright. So you will have two types to think about. One is, and that's traditionally what's meant by copyright, at least in the UK, is the set of economic rights. And these are defined. So there is a set list in the Act itself, in Section 16. And outside of those rights, you don't have any extra rights, if you will. So unless you have one of the acts that are listed in the statute itself being done by a third party, you are not able to stop their infringing actions, as it were. So what are these economic rights? If you are the owner of copyright, and author is the person creating the work, owner is the person owning copyright. So they're the holder of the copyright, of the rights, of the legal instrument. Now, there is a presumption. So if nothing else applies, then the author is presumed to be the first owner. So if I've created something, a piece of art, I am also the first owner under the rules of the statute. Now, if I have been employed by somebody, so in this example, I'm giving a lecture, the lecture is being recorded, but I'm doing that as part of my role at the university. Under the Act, the employer will be deemed to be the owner of copyright, even though I am the author of this particular lecture, or hopefully not too much of a lecture, more of a workshop. So if for employers in this country, at least, if you are creating something, so for example, let's say you are a graphic designer or an artist and you're employed by an ad agency, and your job is, part of your role is to create different graphic designs, different makeups, different, I don't know, ads, commercials, whatever it is, all of that copyright in your creations, in the artistic works you have been making, will go, the copyright, the owner will be your employer, so that ad agency. Now, economic rights are owned by the owner of copyright, but there is a separate set of rights as well that exist under the Copyright Act, and these are moral rights. Moral rights are always belonging to the authors, not to the owners. And there are some that exist, so the right of attribution, the right of integrity of work, but they're very limited in scope, at least in this country. And some have argued that we would need an expansion to those rights. Okay, so there are two sets of rights: economic rights, moral rights. Even as an artist, economic rights are better protection for you if you want to stop third parties doing things with your own works. What are economic rights? So the right of reproduction, so making copies, the right of distribution, so not only selling, but also putting in sale, rental and lending. This is a little bit of an obsolete one, at least in the current days. Then you have performance in public and communication to the public. Specifically communication to the public, I would sort of highlight this one. So this is whenever you put stuff online. So it will cover broadcasts as well, but it also covers things where we share things online. And the final one is the right of adaptation. And just before, I do see questions coming in, but just a brief point on artistic works. So when it comes to performance in public, this does not cover artistic works. So you see that the performance of the work in public is an act restricted by the copyright in a literary, dramatic, or musical work. So that's why you have to pay royalties when we hear songs being played, whether it's in a theater or elsewhere. Or if I was reading out a poem, I would need to have permission, right? The same does not apply to artistic works. And in a similar fashion, and I'm not asking you to read all of this in any way, but I'm just trying to make a point that the right of adaptation is something that should be of interest to you if you're in the music business, or if you are creating musical works, or if you're writing literary works, right? So a literary, dramatic, or musical work will attach also the right of adaptation. This right will not cover artistic works. So when we're looking at adaptations in the sense of artistic works, we're really just looking at what you have taken from other people's works. And if that was only an idea, you're okay. If you've gone beyond that, if you've taken the expression of that idea, then you've gone too far and you might be liable for copyright infringement. Claire, do you want to come in? Yeah.
This one from Martin, he asked, what is the situation with using images of paintings or stills from films in your work, e.g. conference presentations, theses and appendices?
So what, can I just, is there an example of that? I mean, if you were to try to take a picture and use it where? Because if you are trying to use it for your own personal studies, or even if you're trying to use materials, let's say as part of your assessment, as long as you're following the rules of what we have at the university, you're fine. So you have to attribute, and you also have to say where the source is from. So you can use that. Yeah. And we'll see that in the defenses portion, where private study and research is one of the defenses available. What you could not do is use those and then publish that in an online blog without permission and just say, well, these are the materials I've created. If anyone wants to use them, go ahead.
Okay. Martin, I hope that answers your question. If not, please do.
Please come back, yeah.
Yeah, cheers. Okay, this one from Jim. Is there a symbol you can use when you create that lets everybody freely use with no copyright restrictions?
So you can, and this nicely leads us to the Creative Commons license, and it's something I would encourage. And even with things like, so the law school has a Wolverhampton Law Journal, And we've made it a point to make sure that everything we put online, not only our authors sign on to a Creative Commons license, but everyone is made aware of that. So everyone is free to use any materials we publish and so forth and so forth. So my recommendation would be to look at Creative Commons licenses, and you even have the options, they vary a little bit. So if you're happy with people to do mashups with your work, or, repurpose it, or if you're happy with people using it for commercial purposes. So you have different degrees, and it's all really nicely explained, and I'll show you in a little while. But Creative Commons is sort of the license would be my recommendation if you want to signal to the world you're free to do X with my work.
Okay. This one, anonymous. What percentage do we need to change something to class it as a new product? For example, if I took a video of this lecture, painted over it, edited the sound, put new sound on it, would that then be okay?
So unfortunately, I'm a lawyer, so I can't give you a percentage, not because it's my personal preference, although, so you can see the words in red, right? It says a substantial part. So it depends on what you take from the original work. And then once you've taken that from the original work, is it a substantial part of, so did you take a substantial part of my lecture? And substantial part would be assessed through the eyes of the originality of the contribution. And it means we look at the substantiality in relation to my lecture, not your new work. So it doesn't really matter how much you've added to it. So for example, if you were to take a hook from a well-known song, percentage-wise, that might be even just something like, I'm not going to do it, although I was almost tempted to do like a little hook, sing something. But you can imagine that sometimes something in a, it could be like 2-3 seconds, but it would be something we would all recognize. So from a substantiality point of view, it would be something that could lead to copyright infringement, and percentage-wise wouldn't really be even that high. It might not even be 5%. So it depends on what you've taken. Is it the expression of the idea, and would it be considered a substantial part of the protected work? So sorry, and there's no formula.
That's tricky, isn't it?
It is, yes. And that's why lawyers always say, oh, that's why we have jobs. No, the problem is really, there is a serious problem that the defenses that will come up to, so here, brilliantly, so the defenses that are available are difficult to interpret if you're an artist or a creative soul out there trying to source from, all the materials that are out there. We're not creating anything in void. So the law is there trying to say, right, if you're doing research or private study, if you're reporting current events, if you're trying to criticize or review a piece of art, or if you're trying to create parody, pastiche, or caricature, you're allowed to do that as long as you're doing it fairly. And then you have a set of conditions in case law. So you have certain types that will be protected under the law. So if you're trying to create a parody, you can do. The act will say you're not infringing copyright. But you as an artist understanding what will qualify for one of the defenses is not easily made out. So, it goes through. So a good parody should be obviously a parody. There shouldn't be a confusion whether something is just a spin-off of the same work. It shouldn't be hidden as a parody, for example. It's more tricky with things like collage art or even appropriation art. There you might actually get into trouble if you're not, depending on how much you've used in your new work. In the US, they have something that's called free use defense. And as long as the new work is considered to be transformative, there is no copyright infringement. We do not have the same sort of artist defense in the UK system. Okay, I'll stop speaking of that because I see questions popping up. So Claire, do you want to maybe give a question or two before I?
I think what you've said there kind of covers a couple of questions. If you are an artist and you make 10 copies of a print and I buy one of those copies from you, do I have the right to use that image in, say, a book or journal article?
No.
No.
Sorry, that was very abrupt, wasn't it?
No.
It depends on your agreement with the artist.
Yeah.
So if you're just buying a print, then part of that contract is you will place the print somewhere in your house or in your office, and that's it. That's its use. What will also be given to you is to destroy. You have the right to destroy that print if you wanted to. You have the right to use the print and put it in your fridge. So physically, you have all the rights to that print, to that copy. What you don't have is copyright unless you've entered into the agreement with the artist. Because if you were to take a picture of that print and place it in an article, you're doing a new reproduction, you're doing a new copy. If that is placed online, you're actually doing something else. You're also doing communication to the public. And all these separate rights need to be given permission by the copyright owner. So just by way of a selling, and that's the principle of exhaustion, just by way of selling a print, you don't get access to all the rights that exist under copyright.
Okay. We do have quite a lot of questions here. Are you okay to go through?
Of course, yes, let's do it.
Okay. As a freelance designer, when commissioned to design, does the copyright pass to the commissioner on payment?
So please, never leave that up to guessing. Yeah. So you will have, so the way it works currently in the system is that one, depends on what the contract says. And two, if the contract is silent, then usually it will pass to the person buying it. So the courts will say that there is an inferred, an implied term that was part of the contract itself. But please never, as an artist, have that conversation with whoever the commissioner is. What will happen with copyright? Because copyright is a valuable thing, so you should be charging for that.
Okay. Does the life of the creator plus 70 years rule apply to visual artists? For instance, using 19th century artists for an online talk, for instance.
Oh yeah, so if the period has expired, you can use their work freely, yes.
Okay. If you make a painting and I buy it from you, I think we've already covered that actually. Who then owns the image, you or me? But I think you've just sort of.
I think it's similar to the print. Yeah.
Okay. What about using clips images in a quiz that will go online for a short specific time? I suppose that's similar to sort of this session, isn't it?
Well, in a way, that is a very nice segue. So one is, I'll just make a quick note that for any journalist out there, please be aware that even if you are reporting current events, you can't use photographs without permission because the law says so. And I'm happy to come back to this if anyone in the audience is interested. But this is now a useful, so quizzes, right? We were talking around, oh, I found this online. Can I just plonk it into my quiz? I wouldn't. So the way I would recommend is always work from a position of caution. So source your pictures, whether it's for a quiz, whether it's for a talk like this one, or whether it's whatever, your blog, whatever it is. There are certain databases available that will sort of free you up from worrying about it. So things like Creative Commons, and we'll have a look at that. Also, you will see that platforms such as Twitter, Instagram, and others will have very clear rules that if you as a user take something from other people, it's your responsibility to know whether you have the right to do that or not. So the burden is always shifted on us as users. The platform will not safeguard you. The platform doesn't check whether people posting stuff on their platform have copyright in it or not. You're bound to have all the permissions to put things on there, but if you don't, it's that user against the third users. The platform doesn't really get involved. They might have a mechanism for reporting, and all of them do have to under safe harbor provisions. So they will have a link where you say, oh, if there's a copyright issue, click here and report easily here. But again, you could be to blame. Now, where does this come from? I mean, where does this become more and more tricky is not if you're doing a family quiz and it's just you and, I don't know, 10 of your relatives playing something and, you know, it's for personal use, if you will. But for us as lecturers, we should be more aware of where we are sourcing images. And that's why things like Creative Commons is very helpful, because if you find images there, it will also tell you under which conditions you can use them. Okay, so with, for example, with the Twitter one, just to sort of signpost that you see here, any user reliance on any content or materials posted via the services or obtained by you through the services is at your own risk. And yes, that might cover to the, you know, GDPR, privacy and others, but also it includes IP. So, you know, intellectual property and whether or not you have the right to use things you found online is on you. And that goes, they also tell you that you give them license. So be aware also when you are sharing things on different platforms, you're literally entering into a contract with, so you see, by submitting, posting or displaying content on or through the services, so here Twitter, you grant us a worldwide non-exclusive royalty-free license, right? And to use, copy, reproduce, process, adapt, modify, publish, transmit, blah, 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 all of it, right? They're literally taking all the works from, all the rights from your works. So that's something to be aware of when you are sharing materials online. Now, this is, okay, parody, we can come back to this at the end. So Twitter has a very specific set of rules around, you need to be aware of IP rights, and if copyright or other intellectual property rights exist in materials you found on our platform. So that's why when you are thinking about free images, go to CC search. So that's Creative Commons database. And you can see that when you have this search box, you know, I use this always for anything I put on Canvas or in my slides or anything, because it very helpfully, you can sort of find, you know, whatever you want. There's quite a bit, you see it's over 500 million images available. And you can see you can also tick. So I want something I can use commercially or modify or adapt. And the search results will then be the ones with the right license attached to them. So for example, if you search Wolverhampton, you have a range of different results. This was one picture that was offered. And you can see then on, I don't know which side is with everyone viewing this from home, but you can see in the box, so with me, it's in the right corner. I think it should be also with you, but I'm not going to guess. So you see there, it says credit the creator, and it gives you with, you know, what is the title and how you should credit this picture. So I always copy this to place it under the picture where I'm using the picture. And also, if you wanted to click on that particular license, it will also explain then. It will take you to the CC database, to the website, and it will tell you, you are free to share, adapt, and so forth and so forth. Okay, and you can see the licensor cannot revoke these freedoms as long as you follow the license terms. So everything that's made available on the Creative Commons license is there for us to use as long as we follow the rules, and there are different variations of the CC licenses. Hopefully that answers a little bit clear around the using images on quizzes and the like.
That's great, thank you. We've got a question here from Michaela regarding platforms versus users. It seems like YouTube takes responsibility for regulating and removing copyrighted material. Do you have any thoughts on YouTube's approach compared to, say, Twitter?
Oh, I mean, thank you for this question. It's something that's a big discussion point and has been for many years. And Twitter will do the same, by the way. Twitter will just say, because they have to. So if somebody reports that there is a copyright infringement with something that's posted on Twitter, then they will do that. But if somebody were to take a picture from Twitter and then use it elsewhere, Twitter will no longer follow that through. and YouTube the same. So YouTube, as Twitter, as Instagram, and as others, they will have their own mechanisms. Netflix the same, Amazon and others. They have to have mechanisms of reporting intellectual property infringement. If they don't, they lose their safe harbor status, which means that they are not liable. They cannot be sued for intellectual property infringement occurred on their platforms by third parties. So YouTube is doing the same as all these, the rest of them. They have their, so YouTube has the content ID mechanism, and it's working in that regard. But at least from the music side of things, they're not happy with the way YouTube has been offering free services to so many of the users.
That kind of brings us on to this question. How about if using online platforms, e.g. Twitter, Facebook, and you have ticked their private or only me box?
Is there a question to that? I mean, is there a particular conflict? You will still be bound. So when you tick the private or whatever box or setting, it doesn't mean you're not giving Twitter or Facebook the rights. You still are. You're still signing on. By using their services, you're signing on to the terms and conditions. And we saw, so for example, here with Instagram, it will be, you know, they will have a very clear set of rules, what you cannot do. So even if, whether it's public or private, none of these platforms will condone you doing anything with other people if you don't have, with other people's works, if you don't have permission to that. They will also refer you to rules around defenses, fair dealing, exceptions and limitations to copyright, but they will defer to you. You should know the rules. They will not guide you in that. So in the terms of intellectual property and what will happen if somebody else infringes on that, it doesn't really matter whether it's private or public in that sense.
Okay, an interesting question here from Jim. YouTube question copyright on music. I was selling and filming my car. There was music playing in the background. YouTube questioned whether I had permission. My clip, arguably coincidental, was being transmitted many times in full on YouTube by other users. He says he has now removed the clip, but wondered how or why others were able to share. Was it purely down to the fact that they had acknowledged the artist, the label that had recorded, etc.?
No, probably they just weren't caught yet. So they were sharing his video. Is that how it's described?
Yeah, so he was selling and filming his car, and there was music playing in the background.
Yeah.
Yeah.
So in principle, you're not allowed to do that. So, you know, we had these sort of cases where you would have, you know, people either demonstrating certain products or, you know, how-to videos. So in this example, it was around somebody filming their own car, but we've had videos where people would be, I don't know, showing makeup tutorials and there's music in the background. That's an exclusive right that is sort of, you know, it's as if you're playing music on the radio. You have to pay royalties for that. So yes, YouTube might sort of take down your video for copyright violation if you don't have the rights. It comes down to infringement, no, not infringement, enforcement. So whether or not they will come after you for each individual clip. And it's usually attached to situations, either they've sort of identified through content ID, so they will have the algorithm doing the checks and they will ask you if you have permission, or if you start earning money through the ad services, and then the rights holders might catch on to this. But in general, we should all have permission when we're using music in the background. Yeah.
So the other YouTube users then, like you say, probably just hadn't been caught.
Yeah, it wasn't either, it wasn't caught by the content ID, or we're talking about the same clip, right? So there's no reason why this person would be stopped as opposed to others.
Okay.
Yeah, unless they paid, you know, unless they've secured rights from the publisher. Yeah.
Okay. There's quite a lot of questions here.
Claire, do you see a theme developing, and then we'll sort of come with?
There are quite a few questions that that kind of people are unsure at what point you kind of tip over the edge of, then it becomes sort of copyright, you know, whether I change the text or, I mean, I know that you sort of already said, you know, we can't really give a percentage, but there seems to be a bit of concern about what is acceptable and sort of what isn't.
Look, you can always, and this is more of a practical tip, you can always think about, if your work was used in this context, would you want that to be attributed? Would you want to be asked permission, right? So if it's about artistic work and somebody else would be doing what you're doing with that particular work, would you want to be credited for it? That's one way of looking at it. And the other one is just through examples and just through, you know, maybe going into a different workshop again and then just looking at different examples, because that's exactly what the courts will do if it ever comes to that. They will have a look, they'll say, right, copyright protects expression of ideas artistically. You know, in this particular audience, I'm hoping it's easier to understand the difference between an idea and expression of that idea and the way that's delivered by that individual artist. With you know, when you speak around these concepts in a law school environment, it's sometimes a bit more abstract, idea versus expression of idea. But you can all imagine, if I tell you draw a horse, that's the idea, let's do a drawing of a horse, how each one of you will do that will vary substantially. And when you're taking from other people, when you're taking that expression, not the idea. So if I said, Claire, draw a horse, and then you would draw a horse, and then somebody else would do a horse, you couldn't say, Claire, you couldn't say, oh, but I've drawn a horse now, you can't do that. Mm. That's not something copyright will stop. Whereas if I took a picture of your horse drawing and then put it online, you would have copyright in that, and I would have been infringing that.
What about if you slightly change the image or change some text that somebody else has written?
Well, it comes to how much. Yeah. It's a question of degree. Yeah. It's a question of degree. That will then come to it. And again, with literary, music, dramatic, and artistic works, they are protected against indirect copies as well. So even if you just sort of take parts of a poem and you think you've reworked them a little bit, yeah, it's still recognizable if what you've taken from that poet is a substantial part of their poem. You are infringing copyright if you don't have permission to do that, unless you're doing a parody, for example, and that's one of the defenses available to you.
Okay, it's hard to know, isn't it? You know, sort of what, because we can't give percentages. It's really difficult. I mean, if you just sort of change something very minor.
I think it would be also, you know, sort of, what do you think is acceptable practice in your own area? Is something that is encouraged? So is something a question of style? Is a particular thing you're thinking about something that's always done in that way? Or would it be considered to be a step too much? And that's why I think sometimes talking about these things generally is not helping anyone, in the sense that without looking at a specific case, you can't really get an impression or an explanation. So all I can say is that if you were to look at all the different types of works, literary, music, dramatic, and artistic, you have to refrain from taking expression of that idea. You can't copy the original bits that amount to a substantial part of the originally protected work. If you do that, you need to either have permission or one of the defenses will have to apply to excuse you.
Okay. We've got a couple of questions asking if you could explain a bit more about fair dealing and what that means.
Yeah, so fair dealing was, it's a statutory defense. And if you can say that whatever you've done creatively falls within one of the situations, so you have to, there are two steps to a fair dealing defense. First, you have to say that what you've done, let's say you've written a critique, an art review of a painting. And as part of that, you've taken a picture of the painting and you've put it in the article. Yeah. So if it is for criticism or review, or imagine you're doing a review of a book and you've done little excerpts of the book to illustrate a point. Let's say you would say, this particular section is very descriptive. It does nothing compared to some of the other books already out there. And you would reproduce some of the bits and pieces of the book, right, for criticism and review purposes. So first, you would have to show that what you were doing falls within one of the permissible categories, right? So research or private study, reporting current events, criticism or review, or parody, pastiche, or caricature. And you also have quotation, which I didn't put here, and I should have. So that's the first step. And then the second step is that even if the work is of the right purpose, it must still be considered to be fair. So in my example of a book review, what you can't do is say, right, I've reviewed this book and then attach the entire copy of the book and make everything freely available online. That's not fair. So in assessment of what is fair, you have to look at the interest of the copyright owner. You have to look at whether the two works, the one you've created and the originally protected work, would now be in a commercial competition, and whether you're actually taking the market of that originally protected work. Also, what is frowned upon is if you take something that was previously not published yet. So imagine somebody was writing a diary and you would then say, oh, I'm reporting current events, and you would publish those excerpts of a diary, something that the author has not previously done. So that was considered to be unfair in one of the cases. So things like that, that's how fairness is assessed. So first, it has to be in one of the categories. So imagine you're reproducing a particular, I don't know, you're using a photograph in your dissertation. You're allowed to do that because as long as you attribute it, again, under the academic practices and for ethics reasons, but you can use the photograph in your dissertation because that would fall under the research or private study defense. What you can't do then is to say, right, I've done this, or I've done this as a PhD research, I'll publish it now as a book. Your publisher will tell you that if you want to reproduce photographs as part of your thesis, you'll have to have permission from the copyright owner to print them in the book. So the research and private study will not then continue to cover you, if you will, when you decide to publish your PhD as a book.
Okay, Metka, I'm just really conscious of the time. I can't believe
14:59. Yes.
Oh my goodness, there's so many questions.
Should we maybe so 2 points. Please feel free to get in touch whenever. Claire and I will have a look at all the questions and see how we could. I would love to have IP workshops with people from the School of Arts, School of Performing Arts. Let me stop sharing because we don't need that. And we'll just see how we can continue the conversation.
I think so. I think the enormity of the questions, and it is a very, very confusing. It's so marginal, isn't it? You know.
And it's so important for any artist to just have the ABCs, right? You need to know these things. And you know, it's impossible for me to speak to every specific situation in 60 minutes. You know, I've been studying this and researching it since, I don't even know, I'm trying to remember, 2003, 2002 maybe. And still, you know, if you put something in front of me, I would have to sort of look into it and everything. But we have law students as well who've done their copyright and trademarks and others, so we could, you know, work together to sort of improve everyone's familiarity.
I think we should get together and try and figure out how we could do some workshops, because I think that would definitely be useful. Yeah. But certainly the questions that we've not been able to answer today, we'll go away and we'll get a copy of all the questions and we'll email everybody, you know, and the answers, and then hopefully everybody will.
Yeah, and absolutely. If you have any more questions, get in touch. So I'm also on Twitter. I've sent you my email, or you've seen my email, or get in touch with Claire if that's easier. So really, just reach out if you want to. We're quite keen on.
Put my email in the chat.
Oh, I can do that as well. Oh,
I put yours in there as well, Metka.
I did.
Oh, you have. Oh, you didn't do it.
I put my teacher hat now on, you know, sort of like chat and camera and everything.
Yeah, but I definitely think there's scope there to sort of to stretch these sessions out, as I think they're just so useful.
Yeah.
So sorry everyone if we've not been able to.
No, I wish, yeah, I wish we could have like a, you know, and I've had this experience also when I was doing copyright with the MA students, and the beauty was then that they would tell me about their work. Look, this is what I do, and you can speak about issues differently when you see the actual practice. And, you know, when you have, I don't know, photographs, you know, around photography, there's so many different things. So absolutely, yes.
Okay, so we'll take the questions away, and then also we'll figure out how we're going to do some sessions, and then I'll email everybody who's in this session. So if there's anything now that you want to revisit, or you want to join one of the workshops that we'll set up, you're more than welcome to do. Yeah. So but I hope that was useful. Metka, is there anything else you want to add before we go?
Everyone should always know what's happening with their IP. You're the creative talent. You're the ones making the work that's protected by copyright, at least. And it's your asset. So when you create that, you're actually creating something of value. And yes, you'll be pushed around with negotiation skills, and people or businesses have been around longer. Just be aware that this is something you've created. So, you know, knowing a little bit around the rules. And I think it's important to work on this from your university time onwards. It will be really important for you going forward. So reach out, ask. So what we said now with Claire, with myself, reach out, and we'll work around.
Yeah, absolutely. Don't be afraid to ask, regardless of however small you think it is. You know, it could have a massive impact on your professional career. So do ask. Don't worry about sort of worrying about repeating things, because I think I've probably done that today because it's so confusing.
And you know, it's sort of also things like there are specific things around a specific set of areas. So appropriation art, I don't know, putting something in the middle of a gallery or something. You have, and I'm happy to, or, you know, I'll put my PhD researchers on it, and that's what we live for, right? The lawyers, to work with the artists to figure out what will improve your situation in your creative practice. I mean, at least me as a feminist lawyer, that's my approach. So reach out. Now it's on you, right, Claire? Now it's on everyone in the audience.
Absolutely, yeah. I've got no excuses now. Okay, thank you so much.
Absolutely.
You know, let's figure out what to do next. I hope you all enjoyed that and found it useful, what we were able to cover. Our next ArtsFest Online event will be on the 22nd of March, and it's a webinar on the illustrated print for industry and commerce. So that proves to be very interesting. You can book for free through Eventbrite. We hope to see you all there. Thanks for watching. We'll be in touch soon. Bye.
Bye.